Let's apply what we have learned to a hypothetical request directed to the Ohio Attorney General's office. This request asks for copies of all the pictures the Ohio Attorney General has on his desk. The first question we might ask is, are those pictures records of the Attorney General's office or non-records? Well, pictures are visual information on a fixed medium, whether they are glossy prints in a frame or digital files displayed as a computer screensaver, so they meet the first part of the definition of a record. The Attorney General is the official who heads the Attorney General's office, but it's not clear that all of the pictures on his desk, especially personal photographs, were created or received by or come under the jurisdiction of this office. Pictures of friends and family are probably just pictures that the Attorney General brought in from home and were not created or received by the Attorney General's office. However, there may be pictures on the Attorney General's desk that document the official work that the Attorney General does and that may have been created or received by the Attorney General in the course of his official duties. But the Attorney General's pictures of friends and family are personal mementos. They are not kept by the office to document its official activities. These pictures do not reflect the organization, functions, policies, or procedures of the Attorney General's office. Therefore, these personal pictures are not records of the Attorney General's office. Let's take a look at another example. This time, consider a request for a copy of the personal cell phone call detail statement of a particular Assistant Attorney General, Joe Smith, an employee of the Attorney General's office. The requester notes that Assistant Attorneys General get a state employee discount from a particular service provider. The state does not require employees to submit call detail statements in return for the discount, and the Attorney General's office does not require or even use copies of employees' personal cell phone call detail statements for any purpose. The requester notes that, pursuant to his service contract with the phone company, Joe Smith, the employee, himself could obtain a copy of the statement if he wanted to. Is this a request for a record of the Attorney General's office? Again, a call detail statement is information recorded on a fixed medium at the service provider. However, in our example, the public office did not create the statement, it has not received a copy of the statement, and the statement does not come under the jurisdiction of the office. Therefore, the public office does not keep a copy of the statement, and it is not an existing record of the office. In addition, a statement reflecting a public employee's personal calls does not document the activities, policies, or procedures of that employee's public office. Therefore, this requested item is also a non-record that does not have to be produced in response to a public records request. If, on the other hand, a public office provided its employees cell phones to use for work-related business, paid for those cell phones, and kept records and invoices documenting usage of these phones, it is likely that the parts of the statement reflecting the work that was done for the public office would be records of the public office. And what if the same employee was spending all his time at work on his cell phone and his work suffered as a result? The public office's human resources staff may approach this employee and ask him for copies of these call statement details. And once they receive that document, at that point, the public office has them and is using them for an office function to determine whether an employee should be disciplined. And then these documents do become public records. Let's take a few moments to dispel some common misconceptions about what a requester is required to do in order to make a public records request. First, any person can make a public records request to an Ohio public office. That includes someone who is not from Ohio or even from the United States. A person, for the purposes of making public records requests, is not limited to natural persons, but can be a corporation, another government agency, or other body. An Ohio Attorney General's opinion from 2006 confirms that public records requesters can include individuals from other nations and non-governmental and governmental entities from other countries. Unless a particular law requires a requester to identify themselves to make the request, the person can make the request anonymously. My office frequently receives and responds to public records requests from people who choose to remain anonymous and mask their identity by sending requests from email addresses that aren't linked to their names. For example, for a time, we were receiving many public records requests from a Mr. Joe Blow. There are some statutes that require a requester to identify him or herself in order to gain greater access to particular records, and we'll talk about some of those later. However, unless the law requires such identification, the bottom line is that it just does not matter who the requester is, only that they are people and your office is the trustee for the people's records. Requiring a requester to disclose his or her identity constitutes a denial of the request. The Public Records Act makes expressly clear that a public records request can be made either verbally or in writing, whichever the requester chooses. A public office cannot require a requester to put a public records request in writing or require that a requester use a particular form to submit a request. So a requester may make a request in any manner the requester chooses, by phone, in person, or in an email or letter. If a public office receives a verbal request, the person speaking with the requester may wish to write down the request and read it back to the requester to ensure they understand what records the requester wants. A requester also does not have to refer to the Public Records Act, Revised Code Section 149.43, or say any magic words to be entitled to records. All that they need to do is request specific existing records, and the office must process the request. The Attorney General's office often gets requests asking for records under the Freedom of Information Act, or FOIA. FOIA is a federal law that applies to federal agencies and does not apply to local or state agencies in Ohio. However, when my office reviews FOIA requests, the request is generally clear that it is asking for the records of our office, and so we treat and process these requests like any other public records requests that we receive. As long as a public office can tell that the requester is asking for records, it should treat the request like a public records request. It does not matter that a request included a reference to the wrong law. A public office may run into situations where it will help you and the requester to clarify what the requester intends to request. For instance, is the reporter's question a request for an interview or just for records? Is this attorney asking for more documents as a follow-up to civil litigation discovery, or are they making a separate public records request? If more information would help a public office understand what the requester is looking for, then clarify. However, the public office cannot require a requester to give their motive for asking or their intended use of the records. These are the people's records, and they don't need an excuse to inspect them. Requesters may seek records for all sorts of reasons. They could be curious, preparing for a lawsuit, trying to learn more about a particular issue, or even gathering records to resell at a profit. All of those are fine under the public records law unless there is a specific law prohibiting the specific use of the records. Unless prohibited by law, a requester can obtain public records and resell them at a profit. And as I mentioned earlier, a requester can be anonymous. This can be accomplished in a variety of ways, including a requester using a pseudonym or an anonymous email account. The Public Records Act provides that a person can ask to either inspect the records they request or have the public office provide copies of those records. It's up to the requester which option they want. Sometimes a requester will first ask to inspect a set of records and will then ask to just have a few of those records copied. There are a few differences in the public records law, depending on whether a requester chooses to inspect records or receive copies. If the request is for copies, the requester may choose the medium on which they will receive those copies. The requester can select between paper or the medium on which the record is kept on, or any other medium that the agency determines is reasonably available as an integral part of normal agency operations. So, if a public office keeps a requested record in a Word document file and the requester asks for that record in its native format, the public office would have to provide that Word file. Let's look closely at that third option, any other medium that the agency determines is reasonably available as an integral part of normal agency operations. Notice that it is the public office, the agency, that gets to determine if another medium is reasonably available, not the requester. The other medium must be an integral part of normal agency operations. So, for example, if the office keeps video as a hard drive MPG file, but transfers video to VHS magnetic tape routinely as part of its normal operations, both of those options should be given to requesters as one that the agency uses as part of its normal agency operations. As another example, a requester might ask for records that are kept on paper to be scanned to PDF files and placed on a disk or thumb drive. Would a public office have to do this? Well, it depends on whether scanning and the volume or size requested is reasonably available as an integral part of a particular agency's normal operations. If yes, then the public office should offer it. If not, the public office doesn't need to. If the request is just to inspect the records, you will need to set up a time and place to present the records for inspection. Even if the public office is located in a building with restrictions on who may enter all or parts of the offices, you must arrange a place for the inspection. As for when such an inspection may take place, the Public Records Act requires a public office to allow inspection at all reasonable times during the regular business hours of the agency. Courts have held that regular business hours means all times that the agency is performing its formal duties. For police and other safety forces, this may be 24 hours a day, 7 days a week, 365 days of the year. However, even for these agencies, reasonable times will only be the administrative hours of an agency when public access and administrative staff are available. But the agency may not arbitrarily create special restricted hours for inspection within its otherwise reasonable business hours. For example, a public office can't make inspection hours at 2 in the morning. Nothing prevents a public office from offering to negotiate the hours that work best for it and the requester. If an office's normal hours are 8 to 4, but someone could be available after 4 to accommodate a requester inspecting records, the public office could allow inspection after normal hours. If you have a night owl employee and requester, then maybe a 2 in the morning inspection would work for everyone. And it is permissible for the public office to have an employee on hand to supervise the public records requester inspecting records to ensure that the records are not taken or damaged. This may be particularly important if your office deals with very old or fragile records. We will cover this a bit later, but public offices do have a responsibility to protect and maintain their records appropriately.